So hello everyone and welcome to the 2021 Lions Cup round of 16. For all competitors, please ensure that you are muted unless you're submitting. Justices, of course, you may unmute yourself throughout the round or keep yourself unmuted. It's completely your choice. I will be giving you visual time signals like this at 3 minutes. So at the 7-minute mark of your submission, at the 1 minute, so at the 9-minute mark of your submission, and I will be calling time and also showing you a visual signal at 10 minutes. Again, please note the competitors are aware, but please note that there is no additional time that will be granted for these rounds today. Please also ensure that your phone and computer notifications are turned on silent. And as a reminder to the mooters, please do not inform the judges of the schools you represent. Your team number and full names are sufficient. Judges are also not permitted to ask or be notified of school affiliations. Also, a last reminder is that there will be no feedback given after the rounds are over. Competitors are only to return back to the main room where the winner of that round will be announced. I also may take photos for the social media purposes as authorized by the steering committee. And unless there are any questions from me, whenever the justices are ready, we can begin.
So I'm Carolyn Barkley. I'm the Chief Justice for this round. I'm ready to go if my colleagues are.
Ready.
All right, so you may begin with the appellants, please.
Good morning, Honorable Justices. My name is Kapadia, first initial M, and through the screen here today, I'm joined by my co-counsel, Theodora Kakis, first initial E, to represent the appellant, Her Majesty the Queen, in the case at bar. The appellant has 3 submissions for you today. First, we will be submitting that Section 35(1) is a threshold question that should be answered before testing for an Aboriginal right, and the appellant finds that Mr. Desautel does not meet the requirements to be considered an Aboriginal person of Canada. Then, my co-counsel will submit that even if we expanded the scope of Section 35(1) to include these non-Canadian Aboriginal peoples, then Mr. Richard Lee Desautel still fails the claim for an Aboriginal right to hunt under the continuity prong of the Vanderbilt test. And finally, my co-counsel will outline the adverse policy implications of dismissing the appeal at hand, deriving from expanding the scope of 35(1) to including non-Canadian Indigenous people. And it is on the basis of these submissions that we are requesting the Supreme Court of Lions Cup to allow the appeal and overturn the decision made at the Supreme Court of Canada. Would your Honorable Justices like a brief summary of the facts?
No, thank you.
To begin, the appellant would like to submit that Section 11 and 47A of the Wildlife Act are To begin, the appellant must answer the question of whether Section 11 and 47A of the Wildlife Act are of force and effect when it comes to the case of Mr. Richard Lee Desautel and whether he possesses the Aboriginal right to hunt. The appellant respectfully submits that answer is no, that Mr. Richard Lee Desautel is not considered an Aboriginal person of Canada under the definition under Section 35(1) and the definition that we will then propose. And due to his status as a non-resident and a non-citizen, he is unable to claim this right. Section 35(1) must be examined as a threshold question in order to determine whether Mr. Desautel, who is neither a resident nor a citizen of the country, falls within the scope of this provision and possesses this right to hunt.
Counsel, I have a question. Does it say anywhere in Section 35(1) that citizenship or even residency is a requirement for claiming a right?
Your Honorable Justice, while it does not explicitly mention within 35(1) that there is a right for residency or a right for citizenship, it does mention that these protections and the Aboriginal rights and treaty rights are upheld for the current Aboriginal peoples of Canada, and it is the
You're-
appellant's position.
You're right, counsel. It does say of Canada, but do we not have to consider in making our verdict today the Aboriginal perspective as it specifies at Vanderpreet? And when last I checked, the Sinixic did occupy part of Canada at the time of European contact, which could allow us to find that they are indeed Aboriginal peoples of Canada. Why should we not find that today?
Your Honorable Justice, while the tribe may have maintained a historical connection with the land in British Columbia, it is important to find, the appellant notes that it is important that in order to claim a modern day Aboriginal right to hunt in the Sinixt territory, then Mr. Desautel must be a Canadian citizen, as the appellant does not. The appellant submits that these non-residents and these non-citizens of Canada should not be considered.
Sorry,
Aboriginal.
where does the qualifier citizenship appear, counsel? I don't recall section 35 sub 1 or 2 for that matter having any qualification on citizens residents. So where do you get that suggestion from?
The biggest context that we would look to is when conducting a purposive analysis of 35.1 and looking under the linguistic context where the words of Canada are given significant meaning, and under the presumption that each and every word of the text holds meaning, and that this presumption against tautology within
Okay, I'm gonna stop you there, counsel. I'm gonna warn you that I don't like that argument. Of course, the Constitution of Canada applies to the people of Canada and the Aboriginal peoples of Canada. So I'm finding that less persuasive. I'm just wondering how we justify limiting rights to people who are in Canada, and at what point do we decide an Aboriginal right doesn't exist, even though they have common ancestors?
Your Honorable Justice, the appellant is not submitting that the Aboriginal right simply doesn't exist, and we would even like to acknowledge that Aboriginal rights have long predated Section 35.1, and that Section 35.1 of the Constitution Act of 1982 didn't create these Aboriginal rights. It merely gave these existing Aboriginal and treaty rights constitutional protection. Now, the idea before the courts here today is, who do we extend this sacred constitutional protection to? This constitutional protection is meant to protect the Aboriginal peoples of Canada who—
And counsel, that comes back to my earlier question, which you didn't answer to my satisfaction. The Sinixt people do have a connection to Canada. As recently as 1935, there were still people on the reserve that was set aside for them. So we're talking about, within the 20th century, less than 100 years ago, that people were here. What makes them not of Canada? Because as far as I'm concerned, they definitely were. They clearly do have this historic connection that you are talking about. And that would require us to find that they do in fact have a right.
Your Honorable Justice, the appellant would like to maintain that in order to possess a Aboriginal right, in this case for Mr. Desautel, he must also demonstrate that his practice had an aspect of continuity to it, that he was continuing a pre-contact practice that was pre-contract traditional practice that was integral to the culture of the
And counsel, you're absolutely right. He does. So you would agree then that the Sinixt people had a tradition of hunting prior to contact. Is that correct?
While I agree that they did hunt more than the tribes in their area, and as noted in the trial, it was a distinctive and integral part of their culture.
So to be clear, the answer is yes.
Yes.
Following that answer, the Sinixt people also continued to hunt since European contact on their southern part of their territory, which is in what is now defined as Washington State. Is that correct?
While they may have been hunting, there is not enough evidence that has been presented to suggest that they continued the seasonal hunting rounds that they did once continue in the traditional Snakes territory.
So how many elk would he have to shoot in order for it to qualify? Like, honestly, we're talking about a tradition of hunting that goes back to time immemorial. And you're proposing we extinguish that on the basis of what, a 40, 50-year lapse in the tradition?
Your Honorable Justice, it is not about how many cow elk need to be shot or how many other big game need to be hunted for us to recognize the right. We do recognize Aboriginal rights, and we do recognize that reconciliation.
Counsel, no one's disputing that, but I think you need to come back to the judge's question, which is, you're saying there is no continuity. We're saying there is. How do you reconcile that and what requires us to find in your favor?
The appellant simply believes that the 80-year lapse.
Counselor, what you believe is irrelevant. Do you have something to submit or a legal authority?
The appellant would like to submit that the 80-year gap, or as you mentioned, closer to a 70-year gap, and the absence of the Snakes people from British Columbia, and the constellation of factors that did draw them out of the land. That because of these factors, we would like to maintain that the Lakes tribe do not maintain continuity to continue their practice of the traditional Snakes.
Okay, but here's the problem with. Never mind. I'll withdraw my question as you are out of time.
That is time. Thank you.
Is your co-counsel ready?
Yes, I'm ready. Thank you, Your Honor. Good morning, Honorable Justices of the Court. As my co-counsel has previously stated, my name is Theodora Kakis, first initial E, and I will be delivering the final legal and policy submissions for the appellant. First, I will be submitting that even if we expanded the scope of Section 35(1) to include non-residents of Canada, Mr. Richard Lee Desautel's claim for an Aboriginal right to hunt for ceremonial purposes fails the continuity prong of the Vanderpeet test. Lastly, I will outline the adverse policy effects of dismissing the appeal at hand stemming from expanding the scope of Section 35(1) to include non-Canadian Indigenous peoples. To begin, the appellant submits that even if the Lakes tribe is considered an Aboriginal peoples of Canada and constitutionally recognized and protected under Section 35(1), Mr. Desautel cannot claim an Aboriginal right to hunt within the traditional territory of the Snakes in British Columbia. This follows as a test set out in the Crown and Vanderpeet for an Aboriginal right under Section 35(1).
Counsel, assume we know the elements of the Vanderpeet test, but I've got a question for you because I already have a problem. The trial judge already found that there was continuity, and that's a finding of fact. We as the appellant court owe them deference. Why should we overcome this principle of deference in order to change the trial judge's finding?
Thank you, Your Honor. Although we award trial judges a significant amount of latitude when deciding with Aboriginal rights, it is our duty when the lower court has erred to review the findings of fact and to provide a remedy or a suggestion as to why they erred and what we can do going forward.
Right, but it's not simply that they made a mistake, counsel. They had to have made a palpable and overriding error, an obvious mistake, a mistake that renders the finding unreasonable. But I don't see that here. I see that he was reasonably presented with the evidence and made a reasonable determination based on that. So what is your authority for saying we must overturn his decision?
Honorable Justice, the appellant submits that upon reviewing the findings of fact delivered by the trial judge turned to two particular factors to conclude that continuity was established, namely that the Lakes Tribe maintained a connection to the claimed right as the land was not forgotten in the minds of the Lakes Tribe members, and that the Lakes Tribe engaged in the practice of hunting in Washington state at the time of contact. However, the position of the appellant is that there is no direct evidence between 1930 and 2010 that the Lakes Tribe engaged in anything that could be regarded as a modern day practice of hunting in the Sinaiks tradition.
So again, you're asking us to overturn the trial judge's finding based on what? That we need to extinguish an Aboriginal right after 70 years? And furthermore, a follow-up to that is, how does that comply with the requirements of reconciliation and respect of Indigenous people generally that is also mandated by the Charter?
Thank you, Your Honor. The appellant submits here that the finding of continuity is a highly fact-specific case. And in order to find continuity, we need specific evidence to prove that there was hunting in the same manner as their predecessors, so the Sinaiks, in that traditional territory within the 80 years. Now, Justice Cote outlined in paragraph 121 that a single shot—
Sorry, hold on. Sorry, paragraph
121.
121. Sorry, we're on digital documents, so sometimes it takes me a second.
No problem.
Okay, 121, I'm with you.
That a single shot does not constitute continuity, and that this cannot be the standard when we are trying to decide what factors are included in continuity.
Right, counsel, but Vanderfried also discusses the sort of evidence that's required. And there's a breadth of jurisprudence that says that we have to grant a lot of leeway when it comes to historic Aboriginal land claims, simply because the historic records don't exist in the way that, you know, a European colonist might view them. So don't we, again, the jurisprudence compels us to grant a lot of latitude, and back to the principle of deference, we'd have to have a palpable and overriding error to overcome that deference. And I'm just not convinced that you've established that here.
Thank you, Your Honor. The appellant is submitting that according to paragraph 84 Haudenosaunee Nation and British Columbia, Aboriginal claims require that proper and sufficient evidence be gathered and adduced to meet legal requirements for such rights. And although we acknowledge that Aboriginal peoples have rights and that the historical and mental aspect of their culture is a huge part of the integral component of the continuity aspect, we need to see evidence that shows that they were continuing a seasonal round of hunting within that area. And what I believe Justice Cote—
What sort of evidence would, sorry, counsel, what sort of evidence are you expecting? You understand that Aboriginal views of evidence are a little bit different than common law and Eurocentric views of evidence are. So what more evidence would you have wanted from them? They wouldn't have kept written records of this.
Thank you, Your Honor. The appellant is submitting here that although continuity cannot be established simply for the fact that the land was not forgotten, the appellant is also submitting that we would need to see continuous seasonal rounds occurring within the traditional Sinaiks territory to prove that continuity exists. And this is where Justice Cote in the dissent has an issue with the fact that a single shot cannot create the Lakes Tribe modern existence of the right.
I understand that that's the dissent's position, but at the same time, it isn't a single shot. And that is not the finding of fact made by the judge. The finding of fact made by the judge is this activity does continue in Washington, and it's that the geographic aspect of it is not central. But the thing that I would like an answer, because I find it, especially when you consider the honor of the crown principle, I find it very, very difficult for the government to rely on a lack of continued hunting for 80 years in that territory when, as the judge found, there were two major factors that contributed to that. The first being the Oregon Treaty that established a border that, as far as we can tell, there's no evidence on the record that any Indigenous groups, and specifically this one, had any sort of input into. And the second is the Game Protection Amendment of 1896 that essentially made it illegal, which is essentially the starting point for what the very act that he's charged with violating. And so if the government first makes it completely illegal for a non-resident to hunt, puts up a border that increases geographic restrictions, especially when you have essentially a tribe's culture that does seasonal hunting, establishing a border is obviously going to have issues with mobility. So how can the government, consistent with the duty of honor of the crown, how can the government rely on that to essentially usurp Indigenous peoples of their rights and say, hey, it's not continuous?
Thank you, Your Honor. The appellant acknowledges that there are various treaties and policies that have been implemented that do impose borders and hinder hunting for the Lakes tribe. However, when those treaties were imposed, hunting still occurred in the area up until the 1930s. So the Lakes tribe and other successors of the Sinaiaks peoples were still coming to their northern part.
But they're breaking the law. And so are you saying that for them to be able to maintain this continuity, they would have had to break laws? And that's the only way that they could have done, because that is literally the only way they could have done it, is by breaking a law that the government itself established. So it's not even as if it's a third party that was involved. Here it's the same government that subsequently returned those lands to the province that did the damage, essentially, that prevented the continuity.
Yes, Your Honor, the appellant is submitting here that in order to establish continuity, the Lakes tribe members would have had to have shown that they were hunting in the same manner on the same lands in the Sinaiaks territory. And we do acknowledge that there were laws and treaties set in place that imposed borders, but because of the highly fact-specific nature of the continuity test, this is what we would have needed to shown that continuity can be continued on. And Mr. Desautel did hunt once on that land to shoot the cow elk back in October of 2010. But the appellant's main idea here is that in order to establish continuity, we would have needed to see that seasonal round occur more than just once.
And
now,
so just to clarify then, is the government's position and the Crown's position, the appellant's position, that essentially they would have had to break the law, that would have been the way to maintain continuity, and really the only way that you would accept it? And sorry.
Your Honor, can I briefly answer your question and wrap up, or is
No,
time?
I think it's probably going to take too long, so no thanks, though.
Okay.
Yeah.
Thank you.
No, we'll have to call time. So respondents are ready. Whenever you're ready, we are, I believe. Are my co-justices ready?
Yes.
May I please the court? Good morning, Chief Justice and Justices of the Honorable Supreme Court of Lions Cup. My name is Firza Shabazz. I, along my co-counsel, Lila Becky, represent the respondent, Richard Lee Desautel. My friend submitted that of Canada means within the boundaries of Canada. However, an individual can be a citizen of Canada without ever stepping foot into Canada. On the other hand, the Lakes tribe, a group who has been here for thousands of years, that have an ancestral connection to the land, are not considered an Aboriginal peoples of Canada. This conflicts with the purposes of Section 35, Sub 1 of the 1982 Constitution. At issue is whether the respondent's claimed Aboriginal right to hunt for food, social, and ceremonial purposes exempts him from the provisions under which he was charged. The respondents will be presenting two issues today. I will be addressing the first issue, and my co-counsel will be addressing the second issue. The first issue will deal with whether the Lakes tribe is an Aboriginal peoples of Canada, and the second issue will deal with whether the continuity element has been met in accordance with the Vanderpeet test. The respondent respectfully requests that this court dismiss the appeal and answer the constitutional question in the affirmative. I will be making two submissions today. First, I will present the importance of the Aboriginal perspective. Second, I will present the importance of belonging in relation to the land. Beginning with my first submission, I submit that the purpose of Section 35 is to not only recognize and reaffirm the rights, but to reconcile.
So, okay, counsel, that's a lovely opinion. What is your authority for making that statement?
Pardon, you mean authority by where am I getting?
Yeah, you're the legal authority. So where in statute or in jurisprudence do we get that from?
So we see in Section 35, where we're strictly looking at Section 35 and how it encompasses the modern day successors of the next tribe, that which is Mr. Desautel.
But does it? I don't think it says that explicitly, counselor. So what I'm asking is, like, again, these are lovely opinions and they're fantastic policy principles for us to follow. But unless there's some sort of jurisprudence or a statute that we have to follow in making that determination that it encompasses the purposes that you state, we need to have some authority to make that. So I'm asking where it is drawn from.
So the respondent submits that we are drawing this authority from Section 35. That of means with it encompasses those Aboriginal peoples of Canada that were here prior to European contact, that had an occupation on the land, they have an ancestral connection, and it includes those groups, whether they may live in America now or they live in Canada now. As was demonstrated in the Queen and Sparrow. Specifically, I'm referring to Queen.
Hey, counsel, I'm gonna tell you what I'm thinking here. I'm wondering what the potential impact of what you're suggesting would be on the Aboriginal groups currently here. I guess there should be a concern that if we invite everyone from across North America, that we could end up actually taking away from the rights of people who have been here, because we'll have it. There's a potential for a slippery slope, I guess, is what the concern is, that once we open this access to Indigenous rights of groups that do not reside in Canada, how far does it go? Is there any point at which we?
I apologize, Chief Justice, are you finished? Because you cut out for me.
Oh, sorry. Is there any point at which we will be able to cut off access to Indigenous rights?
Thank you, Chief Justice. So to address your question, if in regards to taking away from the Aboriginal groups within Canada, that's not in the duty of the government or the duty of the Crown to consider. These are private affairs between. They regulate themselves and under which they govern their activities. So this would be a private affair between the Indigenous groups of both Canada, that are residing in Canada and residing outside of Canada. And as was demonstrated in Queen and Sparrow.
Sorry, I missed that submission. So just, I don't understand why it's a private matter. This is about constitutional protections. And so it necessarily involves the government and consultation. So I don't understand the submission that it's a private affair between two disparate Indigenous groups.
Right, so thank you, Justice. It's a matter between two Indigenous groups because it's about how they govern their land, how they will divide what their right is, what their land is. It doesn't involve the government because it's their ancestral connection to the land. And if they feel like there's a dispute, there's a conflict of interest, that's between them to resolve.
I'm not sure that's 100% true, counsel, because ultimately it is this court that has to make a determination about it one way or the other. Your submissions are supposed to aid us in that. But I think maybe where we're concerned, counselor, is again with this idea that it's just up to them and we shouldn't interfere, because I think that creates unreasonableness. This land wasn't occupied, not within Mr. Desautel's lifetime, probably not within his parents' or grandparents' lifetime. So how is it that we can find, that they reasonably did, consider use the land when it's been probably about 3 generations or so of time has elapsed between?
Question, just to confirm, just to clarify. So how can we know that he has this ancestral connection?
No. The question is, does not reasonableness and continuity have a role in our analysis? you're saying that, well, so long as Indigenous tribes consider the land theirs, that's good enough. But what I'm saying is that the court has to balance people's rights. And I'm not satisfied your analysis really fulfills that component of our requirements.
Right. So thank you, Justice. But when we're looking at Section 35, we're supposed, in accordance with the Supreme Court of Canada, we're supposed to be looking at it in a liberal, generous manner that not only encompasses the Crown's perspective.
Okay, here, I hit you with this one before, but I'm going to hit you with it again. Why? Why do we have to look at it in a liberal and generous manner? Cannot we simply interpret 35(1) at its plain meaning?
Right, so we have to look at it in a liberal, generous manner because there's a special relationship between Indigenous groups and the Crown. There's a fiduciary duty. There's the matter of the
Okay, so fiduciary duty is another legal term, and it has to be established either by common law or statute. What is your authority for making that statement?
Right, the respondent's authority is that prior to European contact, there was an occupation of the land by the Sinex people, and as the modern day successors of the Sinex, the Lakes tribe have an ancestral connection to the land, and it's always been in their
Counselor, I'm going to beat up on you a little bit because that's not the answer to my question. Authority comes from a decision, either of the Supreme Court or an appellate court,
right,
or a statute.
Right.
Which statute says, one, that we have to construe it in a liberal or generous manner, and two, what decision or statute establishes this fiduciary duty? Because I don't see it in 35(1). 35(1) does not say fiduciary duty. So where does it say it?
Right. So in the Queen and Sparrow, the Supreme Court of Canada in 1990 ruled that the interpretation of Section 35 is to be read in a liberal, generous manner that encompasses not only the Crown's perspective, but the perspective of the Aboriginal people, specifically holding the Crown at a higher regard to take into consideration the Aboriginals' interest. And in Sparrow, the test for Section 35 was set out, in which it says existing Aboriginal rights, it allows for flexibility and for the rights to evolve, as well as recognized and affirmed, is to highlight the appreciation of the history of Indigenous groups and developing that relationship. And the purpose of Section 35 is
just to summarize your submission, what you're basically saying is that because of Sparrow, a liberal interpretation must be taken, and that's an appellate court decision. Is that right?
Right, that is right.
Thank you, counsel.
And so it's really important to take into consideration the trial judge's finding in paragraph 125, when Mr. Desautel was asked what it meant for him to be hunting on the same land, what it meant for him to be in the same land as his ancestors. He states that when I come up here, I'm walking with the ancestors and God. I just think about the times that they were going up the mountain like this here. These are not only heart-moving statements, but they're the truth about their cultural identity and their relation to the land. In conclusion, the issue at hand is modern-day successors like Mr. Desautel have not given up their land or their cultural identity. Their roots are planted in Canadian soil, and to weed out one would mean the downfall of reconciliation. Respected Chief Justice and Justices, it is in the hands. I say I ran out of time.
That's all right, counsel.
Should I?
When you're no, we'll hear from your co-counsel if she's ready, please.
May it please the court. Honorable Justices and Chief Justice of the Supreme Court of Lions Cup, good afternoon, or good morning rather. My name is Lila Belsey. In support of the respondent's position that the Supreme Court of Canada and the trial judge correctly held that the respondent satisfied the continuity element for Aboriginal rights set out in the Queen and Vanderpeet at the Supreme Court in 1996, I will be making two submissions today. My first submission is in regards to any potential issue arising from brief lapses in land use and occupation by the Sinex in British Columbia, and any ambiguity that might arise from these lapses, the court must find in favor of Mr. Desautel. My second submission states that the lapse in question is not a significant enough portion of time to negate the millennia that the Sinixt maintained their occupation and practices prior to European contact, and to disregard
Okay,
that.
Counsel, I'm gonna pause you there. I'm gonna pose the same question I posed to your co-counsel. Are we to have no limit then whatsoever on Aboriginal rights, and what about the risk to Canadian sovereignty?
Thank you for your question, Chief Justice. In regards to that issue, often I think we want to impose a numerical figure on when we can decide when a right can be abandoned or when it can be considered no longer valid. We submit here that this has to be interpreted on a case-by-case basis based on the evidence that surrounds the facts. And in this instance, the evidence of the case would decide in favor of Mr. Desautel. And I'll answer the second part of your question as well, if I could clarify that. I think you asked about the threat to Canadian sovereignty. Is that correct, Chief Justice?
Well, my concern is kind of twofold. So there's a threat to Canadian sovereignty if we can have suddenly have American groups laying claim here. And the other one is, do we not then run the risk of having a slippery slope that could take away from the rights of groups that are currently here, that we already have?
Apologies, your connection seems to be a little irregular, but I'm going to try and answer that as best as I can based on what I understand, Chief Justice. I think you're asking me if this creates a slippery slope for Indigenous groups who exist and reside in Canada currently, if we allow American-based groups like the Lakes Coville tribe to claim an Aboriginal right in Canada. And I would like to respectfully submit that that's not necessarily true. Mr. Desautel's group, the Lakes tribe, has established a long-standing connection with the land through the witnesses at the trial, speaking about the sacred nature of their connection with this land. And there would be obviously a very heavy and intensive investigation into the connection that American groups have to Canadian land. So to say that it would open the floodgates for however many American groups, I would say, is not necessarily accurate, because the level of evidence that we're requiring here is quite high, and the level of evidence that Mr. Desautel is submitting is quite high. I can't necessarily tell you that every group who would make the same claim would stand to that high level of evidence. So there wouldn't necessarily be this massive influx of American groups who are claiming this right.
So Counsel, I think that's fair. But my question to you, though, is how would we have to change our determinations if this weren't about hunting? What if this were about a fishery or mining, where there's also a commercial interest at stake? Do we not run the risk of abrogating the rights of Canadian Aboriginal groups if we allow American groups to begin commercial exploitation through the claiming of titles and Indigenous rights that way?
Thank you for your question, Justice. It's set out in the Queen and Vanderpeet. The central issue of this case, as we know, it is the seminal case for establishing whether there's an Aboriginal right, but the sheer content of the case is based around whether Mrs. Vanderpeet was actually able to establish an Aboriginal right in the commercial practice of fishing. Now, if Mrs. Vanderpeet only tried to establish her traditional right to fish for ceremonial purposes or for sustenance purposes or social purposes, then the test would have allowed her to be given that right. However, we set out that commercial hunting or fishing in the case of Vanderpeet doesn't fall in line with the elements of the Vanderpeet test. So there wouldn't be an issue of American commercialization of Aboriginal rights in this case. I'll move on here, and I would like to address an issue that comes up in the dissent at the Supreme Court of Canada, where Justice Cote mentions that any lapse as in the element of continuity can prove fatal to the right, and that evidence in regards to that lapse submitted by the respondent creates ambiguity and creates a bit of legal invalidation. And I would like to respectfully submit that that is not accurate, as is laid out in the Vanderpeet provisions, that there is no need for an unbroken chain of continuity.
So Counselor, there isn't a need for an unbroken chain, but surely, as I was asking your co-counsel, a lapse of probably somewhere in the neighborhood of 3 generations is pretty significant. Is that not so?
We would submit that it is not significant when compared to the millennia of traditional practice that is established by the Sinixt and was found by the trial judge. There's no question that these people have been maintaining this practice for millennia prior to contact and for over 100 years post-European contact, despite the creation of multiple colonial boundaries and policies that fettered them from maintaining this practice. As my friends mentioned, there's a need for continuing the seasonal element of hunting. However, this seasonal element was fettered significantly by the creation of the Oregon Boundary Treaty in 1846. It was also fettered by the enacting of the Game Act, which made it illegal for Indigenous peoples to hunt in British Columbia. And this, in combination with findings of increased gun violence and death of Indigenous communities and individuals at the time of these enactments, contributed one by one towards the absence of hunting at that time. So if we're asking.
Okay. So I think that's fair, but now here's another question. Let's say we just amended one aspect of the Wildlife Act that said, okay, non-residents can buy a license to hunt big game in the province. Would that not be sufficient to satisfy our requirement to grant a right? And then wouldn't we still be able to find him guilty of hunting without a license if that were the case?
I'm going to clarify your question, Justice. I'm just a little fuzzy. You're asking if we amended the game.
Sorry, maybe I'll summarize. Why can't we just permit Mr. Desautel to buy a hunting license for the purposes of hunting in BC? Would that not be sufficient to acknowledge his right?
Respectfully, that's not what we're asking. We're asking that this court acknowledge the purposive interpretation of Section 35. And in that purposive interpretation, the idea of reconciliation of Aboriginal groups is essential. We have this.
So, Counsel, I'm going to bully you the same way I bullied your co-counsel. What is your authority for making that statement? Why do we have to consider reconciliation at all?
This is outlined quite clearly in the case in the majority ruling, as well as in Vanderpeet. There's multiple instances where the justices involved in these cases cite the need for considering Aboriginal perspective, for considering the mandate of reconciliation between Aboriginal peoples and the Crown, as well as in Sparrow, as my co-counsel mentioned. So these are all relevant in terms of how we interpret Section 35. And when you want to affirm the existing rights, we acknowledge the fact that this was a longstanding autonomous society with their own legal practices and traditions prior to European arrival. And so there's been multiple instances in the cases that we cite here today where this is acknowledged and affirmed. To conclude, if we find a ruling that Mr. Desautel has not satisfied the continuity element, that interpretation would be heavily clouded by colonial perspectives and not with the Aboriginal perspective that Section 35 mandates we consider this case with. Those are the respondent's submissions. We respectfully request that this court dismiss the appeal and answer the constitutional question in the affirmative. Subject to any questions, those are my submissions. Thank you.
I have nothing further if my co-justices don't.
Nope.
Okay, thank you.
Thank you.
Thank you all for your submissions. The justices will now deliberate. So if everyone, of course, besides the honorable justices, could kindly clear the room using the leave breakout room button, not the leave meeting button. You will not be permitted to re-enter, nor will you be told to re-enter, as there is no judge feedback for this round. So please stay in the courthouse lobby for announcements in terms of advancement. Thank you all.
Thank you, justices. Take care.
Thank you.